Dumelang, ke nna Kelelo Mashego, an admitted attorney and notary. September to December is known as wedding season in South Africa, with the month of December being the climax. Ke tibang ka December, go jewa nama every single day. This short video is an attempt at tackling some frequently asked questions relating to the different matrimonial regimes in South Africa. If you are on the journey to walking down the aisle or know someone who's about to have their partner's uncles at their gate, I hope you find the information contained in this video useful. Let's dive right into it. There are two main marital regimes in South Africa. The most common one is in community of property, so let's dissect that one first. In a marriage in community of property, spouses share in everything. They share in assets, losses, profits, gains, debt, and liabilities. I know some of those words may sound synonymous, but the point to not miss here is that in a marriage in community of property, spouses share in literally everything. The famous phrase that's used to describe this type of matrimonial property system is, "What's mine is yours, and what's yours is mine." Another important aspect to consider or to outline in marriages and community of property is spousal consent, which is thoroughly detailed in Section 15 of the Matrimonial Property Act. So what this section basically says is there are certain acts that a spouse cannot take without the other spouse knowing about it and consenting to it. For example, if wife wants to take up a loan, they can't do so without the spouse or the husband coming into the picture and consenting to the wife taking up that loan. And the reason for that is a loan is a debt, and a debt reduces the estate's value. So, one spouse cannot do that without the other spouse knowing. So your spouse always needs to know if you are taking up any sort of act that is going to decrease the value of the estate. Remember, in a marriage in community of property, spouses share in everything, literally everything, including debt which was acquired before the spouses entered into the marriage, and debt which has been acquired during the subsistence of the marriage. The second marital regime that we'll delve into is out of community of property. So two distinctions are made under this type of marital regime. The marriages out of community of property with the inclusion of the accrual system, and out of community of property with the exclusion of the accrual system. Parties who enter into a marriage out of community of property with the exclusion of the accrual system do not share in anything, any losses, any profits, any gains, any liabilities. So simply put, any property or debt that each respective spouse enters into the marriage with become and they remain their sole assets and liabilities. Spousal consent is another important aspect in marriages out of community of property in general. It does not apply in this marital regime. So in marriages out of community of property, basically what is mine, and what's yours is yours. The implications of getting married out of community of property with the inclusion of the accrual system is essentially that the parties will share in the growth of each other's estates on dissolution of the marriage, be it by death or divorce. So essentially, on dissolution of the marriage, a calculation formula is applied, and the parties' estates are subtracted from one another in order to determine which party has a stronger estate in value. And the party whose estate indicates growth from date of marriage up to date of dissolution of the marriage will then need to share that portion of their growth with the party whose estate indicates a lesser growth. An antenuptial contract is an agreement that is entered into between two prospective spouses who do not want to get married in community of property and wish to regulate their matrimonial regime. So, in other words, in community of property is the default regime. If you get married without having entered into an antenuptial contract before uncles are sent out to your father's house, or before you stand in front of a pastor to say your vows, then that marriage would be considered to be in community of property. Whereas with an antenuptial contract, if you enter into an antenuptial contract before, sending out uncles and standing in front of a pastor to say your vows, then that marriage would be considered to be one out of community of property. The most ideal time to enter into an antenuptial contract is before solemnization of the marriage. It's actually not even the ideal time, that's the legal requirement. You should enter into an antenuptial contract before the marriage is solemnized. In the African context where customary marriages are concerned, the best time to enter into an antenuptial contract is before a marriage is entered into in accordance with the spouse's customary practices and requirements for a valid marriage. So it's best to first interrogate and investigate and ask questions surrounding the practices and requirements for valid marriage in accordance with one's cultural practices and requirements. The most careful approach is to enter into an antenuptial contract before the couple or the couple's families commence with Lobola negotiations. Advocate Matabani has actually written a great piece on the subject of customary marriages and their requirements as it pertains to the Recognition of Customary Marriages Act. I will leave details of that written piece on the screenshot. Please look it up and, in case you want to read further on the subject of customary marriages. Given the different matrimonial regimes that we have in South Africa and that we've just outlined, there are some key factors that a couple needs to take into account when having that discussion of which matrimonial regime is suitable for them. Each couple's circumstances differ, and some of the guiding pillars of the discussion between the couple, which I think are important in my view, should be the couple should take their current financial circumstances into account, their future or projected financial circumstances. They should also consider where they want to be financially. What financial goals do they have in the next 5 years, 3 years, both individually and collectively as a couple? What career goals do they have, which could perhaps lead them to having a discussion of a change in matrimonial regime? They should also consider those kind of things. Business ventures, are they looking to venture into business, which could also perhaps lead to them having the discussion of a change in matrimonial regime? Family planning, is the husband looking to be a house husband, or is the wife looking to be a housewife? Those are some of the things that each couple needs to take into account. Of course, this is not set in stone. As I said, each couple's circumstances are different, and this is not all of it. There may be more outside of what I've just mentioned. An admitted notary is the most appropriate person to approach with the request and the instruction to attend to the drafting and registration of an antenuptial contract or a postnuptial contract. An antenuptial contract, which is simply entered into between the two prospective spouses, and not registered at the deeds office is only enforceable between the two spouses only. So that means the agreement only regulates them, and it does not regulate their creditors and other third parties. So having it registered makes it enforceable against the parties' creditors as well, and it notifies them that there is such an agreement between the parties in place. Having said that, it is very important that the parties make sure that an antenuptial contract is not only signed, but it is ultimately registered at the deeds registry in order to have it fully enforceable against creditors and other third parties as well. And this can be quite a complex process, but it is a process which your appointed notary can provide guidance and assistance with. Another crucial point, an antenuptial contract which is signed within South Africa should be registered at the deeds registry within 3 months from date of signature of that antenuptial contract. And if it's signed outside of South Africa, then it should be registered at the deeds registry within 6 months from date of signature of that antenuptial contract. Failing which, the antenuptial contract will not regulate your matrimonial property system. It will become invalid, and it will be as though the parties were married in community of property without having signed an antenuptial contract prior to solemnizing the marriage. Parties who are married in community of property, meaning they did not enter into an antenuptial contract before solemnizing their marriage, can change their matrimonial property system. And how do they do this? Through a post-nuptial contract. So the two parties will need to jointly make an application to the court for leave to change their matrimonial property system. And creditors also need to be notified, and they also need to provide their consent for the change in matrimonial property system. The post-nuptial contract will only be legally binding once the court has made an order that the parties' matrimonial property system has been changed from one in community of property to one being out of community of property, whether with accrual or without accrual. And the post-nuptial contract will then regulate the parties' matrimonial regime going forward. Thank you so much for watching up to this point. Let's engage further in the comment section. And please don't forget to hit the subscribe button. Till the next one, take care.